Subscribe to our YouTube channel and press the bell icon to get the latest updates.
I'm with Saurabh Kirpal, a very well-known advocate, lawyer at the Supreme Court as well as the Delhi High Court. Appeared for two people who petitioned the Supreme Court in 2018, 2 long years ago, to read down Section 377, which criminalized homosexuality. Mr. Kirpal, welcome to ThePrint.
Thank you very much, Jyoti.
So we are here 2 years later, after Section 377 was read down by the Supreme Court, decriminalized homosexuality. You have now written a book called Sex and the Supreme Court. It's been fascinating reading. So first of all, tell me a little bit about the book. The name is very, very evocative, even provocative, some would say, Sex and the Supreme Court. But tell me your thoughts first about why you wrote the book. And 2 years down the line, you yourself, who appeared in the court on behalf of two petitioners. Tell me what you think.
Well, the book, dealing with that first, is an anthology, actually, which I've edited. Of course, I've written a large number of chapters in it. But it's got a mix of lay as well as legal authors. So it has at least 3 former judges who've written in it. Then there are also lay persons who have told a story of their own life. So Ritu Dalmia, Keshav Suri, as well as Zainab Patel, and I think probably one of the most fascinating chapters in the book, Namita Bhandare's, on the Me Too movement. And the use of the word sex, I think, it comes from Article 15 of our Constitution, which deals with the concept of discrimination and affirmative action on the ground of sex. And our Supreme Court has said that sex is a very compendious term. It doesn't deal just with the issue of biological sex. It deals with all issues of sexuality, gender, and so it's much wider than that. And what we noticed was that in the last decade or so, a series of judgments had come from the Supreme Court, which dealt with this larger concept of sex, with the idea of sexuality and transgenders, 377, Shabrimala, which actually had the common thread of sex running through them. It's just that nothing had been written about them as one concept, right? So people talked about each of these judgments in its own sphere. So I felt it important to bring all these issues together and examine it from the lens of the Constitution. And see how is it that the court has dealt with the interaction between an individual and their sex and sexuality and the demands of the community and the pushes and pulls of religion. And that's why it was nice to choose this topic and this format of both laypersons as well as legal essays, because
I think that's what's lovely about the book, is that it has a lot of lay people who have written, and you yourself are gay, Saurabh.
Yes.
And you're gay, you're a lawyer at the Supreme Court as well as the High Court. So first of all, you've written a couple of chapters in this book, but tell me about your own experience and how, as a lawyer, you have been treated by the courts.
Look, I come from a relatively privileged background. So I think in India, before sexuality, there's class and caste, right? So we can talk about the intersectionalities, of course, of sexuality and other things. So personally for me, it was a great experience coming out to my parents, who were very warm and welcoming. It was fantastic. I've been together with my partner for 19 years. That's also, he's a great love of my life. And
could you say something like this before, 2 years ago? I mean, isn't that amazing that it's only 2 years, actually?
Absolutely. And, well, I was out to all my friends and family 2 years ago. People knew it. But even in my legal sphere, at work, I was out, but it was not something I proclaimed loudly or spoke out about very much. So it was kind of a don't ask, don't tell kind of a secret of silence, nudge, nudge, wink, wink thing that was happening, even for work. And this is in spite of the fact that I never tried to hide my sexuality at work. But I still felt it was not possible for me, with all my privilege, to come out as an openly gay man and practice in court. It's not as though I thought that the judges would necessarily hold against me or the clients would refuse to brief me. But you can never be sure. It's a conservative country. It's a conservative society. It's not a risk I could take and also to be branded really as a person who puts sexuality before their work. I felt that if really I have to make a difference, and people, I think, who have the means must make that effort to make a difference, I had to stand out as a lawyer first and a gay person later. So that once I'm established as a lawyer, people will take other gay people seriously because they'll see me and they say, hello, here's a person who is a gay person who's practicing in court and he doesn't have horns on his head. So maybe make it easier for the younger generation, the quieter, the less able, the less privileged, less advantaged people. Let them have a chance. And so it wasn't too bad for me, but that's partly because I internalized it. I wasn't talking about it very much. And the moment it comes out, it becomes public, there are issues that do of course come out.
So this is, your own story, and I'm going to stay with your story a little bit, Saurabh, because it is really, it's a fascinating story of India in a sense. I mean, not just yours, but several people in your book, the 5 petitioners who petitioned against the criminalization of homosexuality. But just explain to me, in the run-up to the 2018 judgment by the Supreme Court, what was happening both inside the courts. I mean, I'm sure you have some idea of what the court was thinking, as well as in the political sphere, because there's no question they must have met somewhere.
Yes, so I think to divorce what is happening in court from politics is a mistake that I think we've all learned recently. Is one that one ought not to do, right? So there is a kind of a syncretic, symbiotic movement between the court of public opinion and the courts of law. And that's not to say that the courts of law are to be completely influenced by politics. Contrary to, again, a large number of people who believe that now, I don't think that to be true. But there is definitely a strong influence that one has on the other. Mm-hmm. And I think that also kind of played out in the 377 case. If you look at its trajectory, forget 2009 in the High Court when the High Court judgment came. I think that was an outlier.
Right.
That was because of the personality of the judges, Justice A.P. Shah and Justice Muralidhar, two great, fine, upstanding judges, brilliant and truly revolutionary. But that's not the common makeup of a judge, right? So the more common makeup of the judge is what happened in 2013, when Justice Singhvi, in his judgment, set aside the Delhi High Court judgment and said that it was up to Parliament to legislate. And at that point, I remember he said in court that he turned to P.P. Malhotra, who was the Additional Solicitor General, and said, do you know any gay people? We don't know any gay people. And that was actually quite a shocker, because even P.P. Malhotra stood up and looked almost offended and scared, saying, no, I don't know any gay person, as with some kind of disease.
The judge said this to P.P. Malhotra.
The judge said, Mr. Malhotra, do you know someone who's gay? We don't know any people who are gay. Where are these gay people? Right? Mm-hmm. The courtroom was full of all of us at that point of time. And the judge doesn't know this. And he was so divorced from the reality of that which was India. And he couldn't even see the fact that there are a huge number of LGBT people out there, because they were not political enough. They were not out there. Right. We hadn't expressed ourselves sufficiently. That's what I mean by a lack of politics and society. And when the judgment came, one of the points the judge made was that we can't give the so-called rights to an alleged minority, to a minuscule minority, right? So no doubt this thought was in the mind of the judge in 2013 that, well, they're politically insignificant and a minority. Now, it's no part of the Supreme Court to say that, right? I think it was an abdication of their responsibility and frankly, a violation of the constitutional oath of office. But they are judges, and that's their job, and that's what they did. By the time the judgment came to 2018, I think there was a change in society in those 5 years, really. I think the animus, so to say, had been let loose in 2009 when the Supreme Court, but the High Court had ruled that you could not have homosexuality as a criminal offense. people had come out. There was a strong no going back movement, and in fact that worked. So people weren't willing to just take the 2013 judgment lying down.
Right.
Civil society wasn't. I think attitudes changed because of international pressure, what was happening in the US, the idea of gay marriage, adoption of children. We're living in a very interconnected world now. So I thought society was changing. And so when the matter came to 2018, I think leading up to it, I think the views of the government by that time had also begun to change. I think they were ambivalent, but they had...
Ambivalent in what way? This was the Modi government in 2000.
The Modi government.
But why do you say it was ambivalent?
Ambivalent, well, one is frankly the affidavit that they filed, which was that we leave it to the court to decide as to what to do, right? If you are certain that homosexuality is a crime, you'd come up and say, no, retain section 377. And if you are the other way, you would say, no, we support striking it down. So please read it down. The government didn't file an affidavit either way. They simply said that we leave it to the court, to the wisdom of the court to decide one way or the other. And the ambivalence was kind of obvious, Jyoti. I think if we go back to just a few months before the hearings had begun to commence, the government had not filed an affidavit stating their stance. In fact, the solicitor, Tushar Mehta, sought time from the court saying that, look, the government is trying to make up its mind as to what kind of an affidavit to file. The Chief Justice at that point refused him that permission and said the matter has been pending and we intend to hear it. And
what do you think he was referring to, Tushar Mehta? Obviously, there must have been some discussion going on inside the Modi government. Is that what do we do with this matter, right?
Exactly. I think there were pulls and pushes within government. There was the more conservative lobby, surely, which was saying, how can we permit something like this to happen? And I suppose the more progressive, whatever you can call, of the government wing, which said that, no, this is something that we need to do and we need to move out. And I suppose they found a kind of a happy compromise, the hands-off approach, by saying that we leave it to the court. And really, this affidavit
at the time was that, sorry to interrupt, but what I heard at the time was that Arun Jaitley, the late Arun Jaitley, was very much in favor that the court look at this and strike it down. Am I correct?
I don't think there's any doubt about it. He, Mr. Jaitley, I think, was a great friend of the LGBTQ community. I think we owe him a debt of gratitude, which has not been expressed often enough. He was a friend, he was an ally, and he wasn't even a silent ally. I think he'd spoken out often about the fact that he thought that the 2000 judgment was wrong. I'm not going to detail my personal conversations with him, but what he believed openly, he said personally as well. So he thought that the time had come for the court and indeed for the country to move on, and we couldn't have such a provision. So I think in the end, his view sort of prevailed in the government, and therefore I say I'm thankful to him. Unfortunately, we don't have him today for the other battles we need to fight, but at least for this big one, I think it was really his effort which pushed it. I don't think we should. I can't lay enough stress on that.
So by 2018, September 6th, and we're marking 2 years of that incredible anniversary. So my question to you is, Saurabh, is that the country had moved on, as you said, but the Supreme Court clearly hadn't. So in a sense, the Supreme Court was catching up with the country, right?
Well, I think another mistake that we make is, what is the Supreme Court, right? There are 34 judges in the Supreme Court. And I can give you, and they sit in benches of 2 often. So I can give you 17 separate Supreme Court. The constitution of the bench in 2018, I think, was the most important thing. And that was up to the Chief Justice as the master of the roster to constitute that bench.
Right.
And I think pretty much from the day when the bench was announced, we knew that we were on a stronger wicket than we otherwise would have been. Mm-hmm. So there was, of course, the Chief Justice who would pluck this particular case out for hearing. Now, there was no reason for him to choose this case as opposed to the hundreds of other cases of constitution benches which were referring, unless he had some idea of what he wanted to do. And then there was Justice Chandrachud, Justice Nariman, Justice Jyoti Malhotra, Justice Khanvilkar, the 4 other judges, all 4 of whom who come from the metros, 2 from Delhi, 2 from Bombay, liberal outlooks. So I think that was important. I can assure you, Jyoti, that in 2018, had there been another Chief Justice, he could very well, I would say he because there's no chance of a woman being a Chief Justice anytime soon, he would have found 4 other judges who would have held exactly the opposite way, right? So I think to say that the Supreme Court was following the mood of the nation, yes, to some extent it was, but I think it was also the Chief Justice trying to either speak to history or recognizing the mood of the nation. And that's important. It's not the Supreme Court per se or en banc which recognizes the mood. It is very much the Chief Justice, I think. We don't acknowledge that enough.
So the Chief Justice at the time, Deepak Mishra, and I loved in your book, and it brought back a lot of the moment actually. And he writes in his, or says in his opening phrase of his judgment, where he quotes from Schopenhauer, the German poet and philosopher, and he says, "I am what I am, and take me as I am."
Right.
I mean, that's very moving, isn't it, in a sense?
Absolutely. I think the judgment was kind of as much a legal exercise as it was a poetic exercise. Of course, with Justice Mishra's judgments, we're used to poems, and increasingly I find the Supreme Court verdicts to be more poetic than legal, but that's another discussion for another day.
Right.
But I think they were dealing with a rather emotive subject, for at least for a lot of us who are gay, from the LGBT community, and for the country at large. And I think the recognition of the idea of autonomy and privacy, and I think there was a belief in the moment that we have to stand up for the values of the Constitution. And we have to give every citizen their full citizenhood. Now, these are verbal formulae which can be bandied about, But I think the hearing, and during the course of the hearing, there was an electric atmosphere in court. And I think the court was conscious of the momentous decision it was taking. The yoke of slavery that had been thrust upon the LGBT community was being lifted. I think they were conscious of what they were doing. And I think they were conscious of the fact that they had taken an oath to the Constitution and to uphold its values. And they were aware that they were living up to it. And to me, it was an open and shut thing, really, as to how the 2013 judgment could have come. It beggars belief, but it had come. So I think it was an easy task for them, and it was an emotive task for them and for us.
Right. I mean, 1860, when you think about it, this section 377 was sort of formed in 1860. I mean, 3 years after the first War of Independence, right? 3 years after 1857. So it's just staggering that it took so long for the Supreme Court to actually come around to just making everybody equal. I think that's quite.
Yeah. I think it's fascinating. Really, it's 1860. Of course, as a matter of history, it goes back even further, because the Macaulay Commission had been commissioned even before 1857.
Right.
So it's only in 1860 that the Penal Code came, and the discussions are fascinating, actually. Macaulay couldn't bring himself to give the term sodomy or homosexuality in the section because he felt so appalled that you can't even mention it. And you're right. From 1950 onwards, it was 2018, almost 70 years later, that the Supreme Court finally struck it down. For the first 50 years, I think we wouldn't even have dealt with the issue of homosexuality. Right?
But why not?
Because it was completely brushed under the carpet in India. The first litigation really started in 1990, on the AIDS Vedbhav Virodhi Andolan. That wasn't mentioned in the court or anything till about mid-90s when it was dismissed. But in the public conscience, there was no LGBT person. There was nothing really out there. None of us came out. None of us discussed ourselves. The media didn't discuss anything. The courts felt we were an invisible minority, and this was not an important enough issue. And also, I think there was a fear that the courts are very conservative, and therefore we should not challenge that provision then. So I think that's what it takes courage to fight as well, right? I think people didn't probably have the courage in the first 50 years, because to say that I challenged Section 377 meant that you were exposing yourself to the criminal process as well. You were saying that I am a gay person and I am scared that you will convict me of Section 377 and send me to jail for life. So please read it down. But if there was a very, very difficult government and wanted to persecute you, they would have said, well, here's a candid admission on your part. You've admitted you're a gay person. You must have indulged in these acts of sodomy, and we're coming after you. So I think there was an element of fear as well, which is what was different in 2018. And that's what I think the 2009 judgment did for us. Because till 2013, no gay person had directly come out and challenged this provision themselves. It was always through an NGO, through parents, through allies. And it was Navtej's petition, which was the first petition.
The classical dancer.
Navtej Johar, exactly, which is ultimately the name of the judgment bears his name. Navtej Johar versus Union of India in 2018, 6th of September judgment. So it was 5 people who'd come together. Navtej, there was Aisha, Ritu, Amarnath, and the 5th was Amarnath. Aisha filed separately as well, his own petition.
Yeah, right. So, but I have 2 questions from that, Saurabh, from your last comments. The first is this fear of the state peeping into your bedroom. I mean, they have no business to invade your privacy, and yet that was the fear, wasn't it?
Right. Well, the state has no business doing a lot of things, right? But who's to enforce that? We have this beautiful text called the Constitution, and we have all the protections in the laws that have been written in. That if they're violated, what is to be done about it, right? We bank on the courts to come to our defense. And I think there was a feeling that till the earlier part of the 21st century, the courts probably wouldn't have come to our defense. I don't know what we can say about the court today as well. But as a citizen, really, the only chance we have is to appeal to the Supreme Court, to uphold its constitutional obligations and come and protect our rights as individuals against the bulk of majority hatred. Yeah. And hatred is exactly what existed for the LGBT community, I think, till 2018, or maybe not 2018, but till the early part of the 21st century. There was, at the very best, a kind of a mocking disdain, some little bits in movies where you laugh and twitter and giggle if you see some person who's rather effeminate, to downright hatred of the LGBT community. So I think that's what the fear was. And that fear in society reflected itself in your fear that the court may not stand up for you. And then what? Then where are you left if that happens? And that's what's really brilliant about this judgment is I think the most notable thing about this judgment has been silence. Out comes this judgment of 2018, and there were pulls and pressures within the government as to what kind of affidavit we file, do we support, we don't support. And there is not a whisper that I've heard, at least in any large sense, of anyone opposing the outcome. I think this had become blasé, this had become normal, it's become internalized, and it just shows how the society has moved. Yeah. And how, even in 2013, I think this was a low-hanging fruit that was ripe for the plucking for the Supreme Court if they'd chosen to have even just a bit of courage to do so. But that's what it is.
Perhaps you should have cited Hindu scripture, chapter and verse, to tell politicians across the political spectrum, since they're so interested in matters of the law, that in Indian sort of the ancients completely acknowledged and celebrated homosexuality because it was just another form of sexuality. But I have another question for you, which is that the Supreme Court obviously didn't go far enough. I mean, homosexuals cannot still get married, right?
Correct. Look, but that's the nature of, I think, constitutional adjudication. And I think we have to be slightly fair to the Supreme Court here. The issue before them was the Section 377 and its constitutionality. The way court ever decides is it decides the issue before it because it can't foreclose another issue which may come up some point. It builds layers of precedent. It develops a body of jurisprudence, which then help later judges to rely on earlier precedent, earlier law, and earlier established principles to apply to a modern or a current context. So while this court, I think, has not ruled on gay marriage because the issue wasn't before it, I think if you read the judgment carefully and analytically, it's basically laid a very clear roadmap, in fact, for future judges to come and rely on this judgment and say that gay marriage should be permitted in India.
Does it
And
say
it doesn't, it alludes to it at several places.
right?
It repeatedly bases itself. The judgment is based on the idea on the ability of a gay person or LGBT person to love a member of the same sex and treat that relationship as equal to that of a heterosexual couple. Right? That's the fundamental basis of the Article 14 argument, the right to equality argument. It's a fundamental basis of the Article 21 argument, that is, that to achieve your autonomy as an individual, you should have the right to choose your sexual partner and your partner in life.
Yeah.
Right? So the moment you make that comment and you make that statement, it's only a short step, I think, really, in terms of logical reasoning, to say that if you allow me to have my own sexual partner, you recognize the worth of having a partner and having a stable relationship, then really, frankly, marriage is nothing but that very same relationship with the imprimatur of the law, right? And that's something I talk about in a different chapter of my book about the nature of marriage, which is really, it's a societal construct with the series of legal rules which have been cast upon it. So I think the judgment has laid a roadmap towards the legalization of gay marriage. It hasn't done so itself, but I think that's how constitutional adjudication works. And I hope at some point soon we'll have a judgment on that as well, which will be favorable.
So last couple of questions, Saurabh. The one on your book, where, one of the reasons why I love reading it is because it has so many different manifestations of, sex, sexuality, whether it's in marriage. And there's a chapter on transgenders. Another one on adultery.
Right.
So tell me a little bit about how you picked these people, or did you ask them to write for you? Arundhati Kaju and Menika Guruswamy, who also petitioned in this particular judgment. Keshav Suri. Did you ask these people to write? Or
yes,
how did this happen?
Well, I reached out to all of them. I tried to find the best person for each topic. So I had in my mind which were the various topics that had to be covered.
Right.
And what's interesting is, at least of the 6 or 7 issues that have been dealt with in the book, at least in 3 of them, it was the same constitution bench which decided them. So the Sabrimala judgment, which is the right to enter the temple, the adultery judgment, as well as the 377 judgment, all 3 were by the same constitution bench. So they were really proximate in time. But going back to the choice of authors, I think it was important to get a mix of the finest legal brains who would be willing to write on these issues, and also people who could give a personal perspective of what these judgments meant to them. Because the idea of the book is to reach to a lay audience without, as I was telling you earlier, Jyoti, without dumping it down, right? So for that, it was important to have a mix of both legal and non-legal people. And the endeavor was to find, for each of these topics, people who had either a personal connection with it or had a robust intellectual capacity and had dealt with similar issues to write about each of these things. So when we so that was what determined it.
No, I think it's fascinating because, Ritu Dalmia is saying in her chapters about, I'm a chef who's a lesbian, not a lesbian who's also a chef. So, just sort of inverting the whole paradigm and telling the world, hey, my sexuality is my business, not yours.
Absolutely. That's what I said earlier at the beginning of your interview, that I'm a lawyer who happens to be gay. Of course, these days, the amount of stuff I'm doing and lectures I'm giving, I think rather than being a homosexual professional, I become a professional homosexual. But
on that note, Saurabh, you have to tell me that, your name has been put up as a potential judge of the Delhi High Court. But for some reason, each time we read about the new list that comes up, you're never there.
Well, always the bridesmaid, never the bride, huh?
Is it because you're gay?
Well, you see, this is all mired in a cloud of innuendo and stuff. It's been really over 3 years since I was first asked to be a judge, right? I remember on the 22nd of April that I was asked, 2018, 2018. No, 2017 actually, April 2017, that the judges first reached out to me and said, would you be willing to give your consent? And how old are you? I just turned 45, which was the limit, 4 days before. And I was very, very conflicted as to whether to accept. My work was doing very well, and I'm lucky it's still doing well. So to give all of that up, to give up my freedom, to give up money, was a tough call for me. But I chose to do it because I thought it was important. It was important for the community to have a role model. It was important for the bench to have diversity. So I accepted it. But thereafter, I think there was a series of less than pleasant developments. So first, I don't know, some kind of an IB report came, which I don't have access to, but you only read through media. And then it was deferred once, it was deferred the second time, it was deferred again last, I think, in April of last year. And it's sort of hanging fire. So I really don't know what's in the mind of the judges.
What was the IB report that you read about?
It's an article in the Economic Times that I'd read. I think it's something to do with the fact that about my partner, but I think this is really a smokescreen. It's probably to do with my sexuality. I don't know. See, this is the problem with the collegiate system. It's completely opaque, right? And because it's opaque, so I can't say what the reason is. All I can say is that I'm not about to back down from this. If the court doesn't want to make me a judge, it should be on them. It should not be on me. I took a call to do the right thing, what I believe to be the right thing. I've always fought by certain moral standards in my life, and I'll stick to them. Well, I hope the next good news from the Supreme Court is gay marriage, but I think there are a few other things before that have to happen. I believe there has to be an anti-discrimination law. There's a long, long battle to be fought yet for the LGBT community. I think gay marriage is one part of it, and we can't forget the other parts, other battles that we have to fight. And I believe we can fight all of those battles together. We have sufficient bandwidth, I think, to engage on fronts. So the transgender bill has to be opposed. So I think we have that fire within our belly to do all of the above. And you know what? Contrary to a lot of pessimists, I have great hope for our Supreme Court. There have been hitches, there have been hiccups. That's happened in the past. That's destiny, that's life. But the arc of history, as they say, is long. And I think it bends towards justice, as has been said. And that's my belief.
Well said, Saurabh. Thank you again for your time, and do continue to watch us, read us at ThePrint, and tell us what you think. Thank you again.